Hello, everyone. Welcome. Thank you for coming. This is always a small group because, those people are intimidated by this and don't want to think about it. But I think it's always really valuable. And we do record it and post it on our website. So if you have friends who really would have liked to be here, you can let them know that. I did also, out on the table, I put some of these, which are specific to Crossroads School because we're hosting this. But they also have some really good information about different kinds of gifts besides cash. So whatever charities you support, this is some good ideas for ways to get tax benefits in your estate plan or even in your giving now. So you're welcome to grab one of those. And if you wanted to give to Crossroads, I wouldn't object, so there's that. But really this is an opportunity for us to just get some good information from Julie. Julie Karavas has been a friend for many years, a friend of Crossroads and a friend of mine personally, and is an amazing estate planning attorney. One of the things I love is that she really likes to take on the really complicated things. So, the farms that need to be included in an estate somehow, and the disabled kids that need to be provided for, and those kinds of things. So she's an incredible resource, and I'm excited to hear what she has to share with us tonight.
Good evening. Thank you, Barb. And as Barb said, I'm Julie Karavas, and I am an attorney. I have an office in Boulder and then also in Nebraska, and I'm licensed in both states. Practice involves a lot of transactional work, estate planning, a lot of wills, trusts, and then administering estates when someone does pass. A lot of work with families that have what I would refer to as special kiddos, that we need to have special documents and plans for them. Do a lot of work with families that have closely held businesses, a lot of agricultural families where there's that necessary overlap of business of the farm or the ranch, and then the personal interest as well, and how do we make that all work. I have a very strong tax background as well, so those are the kinds of, or that type of issue I'm always trying to keep in mind when I work with clients, with families, to make sure that we do involve an accountant, a CPA when necessary, but I do speak that language so that we are able to deal with all those annoying tax issues too. I have had the pleasure of speaking to groups like you before. Barb's asked me to come and present in the past, and we always try to think of what's something that could be somewhat riveting to get people here rather than, just saying estate planning, because most people don't wake up in the morning and say, that is the one thing I want to do today. So in the past, we've talked about general estate planning, have done some more detailed discussion with trusts. What I thought might work today, and a few of you at least had some interest, to see what are some common mistakes that people make in doing estate planning, or quite frankly, not doing planning. And I am going to try to go through kind of 10, the top 10 things I thought of. And if you have any questions as we go along, please do ask, and I'll make sure to save some time at the end. But if you do have a question, don't hesitate to ask. You have my information, if you picked it up on the table out there, both on the handout and then a card. And as I will remind you at the end, if you do have any questions following tonight, please do give me a call. Just make sure you tell me you're here, and I'd be happy to address any initial questions you might have without my clock running, so to speak, okay? So, first of all, I guess I'm just curious, and don't worry, we're not gonna have a lot of interaction, or I won't make you answer a lot of questions, but I'm just curious, do any of you have any sort of estate plan in place, wills or power of attorneys, or, okay. Well, I think what I would consider to be a mistake number one that people make is to not have a plan at all. There is sometimes a misconception that if you don't have a plan, and I'll go through what that means in a moment, is that the state, so if you're in Colorado, that the state just takes your money. Well, the state, or your assets, the state doesn't do that, but the state, in state law, does have a plan as to how that needs to be allocated, or who will need to step in and act as your agent, and those sorts of things. So I think one overriding thing that I would like you to remember is an estate plan really isn't just, for some reason people think, oh, you have to have a certain amount of money or you have to have a certain family situation. That's not true. It's about choice. And so if you want some choice in terms of who can serve as your power of attorney or who gets your assets, then you need to have an estate plan. I will touch on real quickly what I'm talking about as an estate plan, especially if you don't have one or if it's been a while since you've thought about it. An estate plan generally consists of at least a few documents. A couple of those are power of attorney documents, like a financial power of attorney, also referred to as a durable power of attorney. And what that is if it's yours, so if it's mine, I, Julie, would be the principal on that document, and I'm naming an agent to act on my behalf. So someone for financial purposes would be able to write checks. If I had to sell real estate, talk with the insurance company, I'm giving someone the right or the authority to do that. It doesn't give them ownership. Similarly, there's power of attorney documents for health and medical reasons. So if you need, again, if I'm the principal, I'm naming an agent, someone that can talk to the doctor, someone that's at the hospital, if I'm in the hospital, that has the authority to speak on my behalf and get medical information. Then most often people think of an estate plan, they think of a will. Okay, a will only comes into play after you have passed away, and we'll talk a little bit more about that in a moment. And then on occasion, trusts also come in. But those are the kinds of documents that you would have written up if you have an estate plan, okay? If you do not have any sort of estate plan, so you haven't stated your preference, your choice, then it can get very costly. And by costly, I mean in terms of, and I see some head shaking, in terms of expense, in terms of what you're going to have to pay a lawyer because you're reacting. You haven't planned. You're just, I often say if you do planning, you're investing. If you don't plan, you're reacting and it's all an expense. You don't really have control. You're just having to deal with whatever's being thrown at you. The other way it can become very costly is the phrase that I use is you can have a lot of family dynamics. And if you have not made your choices known, then everybody thinks they can be in control. It also, not just with assets, but a moment ago I talked about power of attorney documents. If you do not have a power of attorney document and you get to a point where you lack the mental capacity to prepare a document that says that you want someone to act on your behalf, then that's when you hear of people having to get guardianships or conservatorships in the court. A guardianship has to do with the person, like where do they receive medical care, where do they live, that sort of thing. A conservatorship deals with assets. And I do a fair amount of those, and as I said, I have the privilege of working with families with special kiddos, and in those cases, when those children reach the age of majority, when they become adults, we have to get guardianships. That can be very rewarding, and that's worthwhile. But for all of you sitting out here, if you don't have a power of attorney and you lose mental capacity to be able to prepare a document, it may sound very strange. I don't like doing those kind of guardianships and conservatorships because they are very costly in terms of legal fees, the time, what needs to be done for the court, and then the court stays involved. and there's annual reporting. It can get to a point where you're actually having to ask permission from the court as to how money is spent. And depending on how that comes about, you can also have family members fighting over who should have that role, okay? So those, you might not have ever thought of the last few things I talked about in terms of an estate plan, but that is part of that. So the other, yeah, we'll come back. There's one other issue I'll talk about in a moment. Mistake number 2 I often find is people say, well, I have a will, so my estate will avoid probate. No. Let me tell you what probate is. Really the only time we think of probate and non-probate is when someone has passed away. Assets are either probate or non-probate. A probate asset, if we look at the face of it, and when I'm talking about assets, I'm talking about something with paper, or an account, something that you need a document to be able to transfer ownership. I'm not talking about your couch or your dishes in your kitchen, something that you need to use a paper to transfer. Probate asset, we look at the face of it, it doesn't tell us who gets it when you pass. An example is a car title. If your car title just has a single name on it, that's a probate asset. Your car title doesn't tell us who gets it when you pass. A bank account that's just in your name, okay? If you have probate assets, your will, if you have a will, controls who gets those. There's a process that the will goes through the court, and then the court appoints the personal representative. The older term is executor. It means the same thing. They just had to change terms. And if you don't have a will, we still go through that process, but again, you don't have the choice. So probate assets are controlled, the allocation of them is controlled by what is in your will. So a will doesn't avoid probate. The will is the vehicle that we drive through probate, okay? I'll finish my thought as to what non-probate assets are so that you understand that. Non-probate assets are not controlled by your will. A non-probate asset, if you look at the face of it, it tells us who gets it when you pass. Examples, jointly owned property. If you're married and you and your spouse own your home as joint tenants, the deed says joint tenants with rights of survivorship. So the first spouse passes, automatically that survivor becomes the owner. Even if you have a will, your will does not override non-probate, okay? Other examples, life insurance with a designated beneficiary. It tells us who gets it, so your will does not control. Bank accounts with pay on death, POD designations, brokerage accounts have the same thing, but for whatever reason, we call those transfer on death, TOD designations. Anything that says who gets it when you pass is non-probate, and your will, even if you have a will, the will does not override that. So if you have a will, you can be very specific as to who benefits from those probate assets, but you still have to go through probate. You don't have to, but I'd say 95% of the time people hire lawyers to help through that process. Probate can, it isn't necessarily extremely expensive, but it costs some money to go through the process because it's a court process. It also, in the kind of 24/7, there's an app for everything world that we live in now. Probate is probably one of the slower processes. It can go on for months. It can go on for a year. And it's not that we wait till probate is finished to transfer the assets, but there's certain things that must happen as we go through probate before assets can be distributed. So how do you avoid probate? You could use a trust, and I'll talk about that in a moment. I just talked about non-probate designations, because not only does a will not control the non-probate, like the life insurance or that joint tenancy on your deed, but if you have those non-probate designations, then you don't involve the court. So if your deed says it goes to my surviving spouse automatically, you just file the death certificate with the county and you're done. If you have the life insurance with a designated beneficiary, you give the insurance company what they want, the money goes to the beneficiary, you're done. You don't involve the court. However, this can be it is a very fluid process. So using the idea of a joint tenancy deed, at the first death, that's non-probate. It automatically goes to the surviving spouse. If that surviving spouse does nothing more with that deed and that person passes, well, at that time, that deed was probate because it only has that single person's name on it, and that person's will would control. So you can tell, probably without me even saying this, that there's a lot of coordination that needs to be done to make sure things happen the way that you want them to. So let's look at number 3, the misunderstanding trusts. If you only have a will, sometimes that's fine. I'll meet with clients and sometimes we decide, that's probably the most efficient way and that's all that is needed. But there is less privacy because that document becomes a public document with the courts. It can be very costly. So sometimes people will think, well, maybe trusts would work. And given the example I just gave you about the deed and how it can go from non-probate to probate, that's one of the times that we can talk about a trust. But I often hear people say, well, I don't need a trust, or I can't have a trust because that's only for people with with a lot of assets, very affluent people. Not necessarily. Trusts can be used, and when I talk about trust, I should also explain, there are a number of types of trusts that can be used. What I'm talking about are trusts for estate planning purposes that have a number of names. Joint, or they can be called living trust, revocable trust, grantor trust, settlor trust, all means the same thing. And so with the misunderstanding of trusts, what I would like you to understand is that there's 3 main roles or three types of hats that are worn with a trust. One is the settlor, also referred to as a grantor. That's the person that establishes the trust. So if I'm making a trust, I would be the settlor. That person can also, with the type of trust I'm talking about, you can change it during your lifetime. And sometimes people, usually married couples, will have a joint trust where they're both the settlors, they can both change it. It's kind of like a common bucket they can put things in. The second hat you wear when you have a trust is as trustee. And the trustee is the one who carries out the provisions that we have put in the trust. So if I have a trust, I can be the settlor as well as the initial trustee. The third role, or the hat that is worn in a trust, is a beneficiary. That's who benefits under the trust, okay? So if you use a trust in estate planning, go back to what I was talking about with non-probate assets. Anything that is already, we say, funding the trust or titled in the name of the trust when you pass is non-probate. So if you title your house in the name of the trust, so the deed says the Julie Trust, that's non-probate. Trusts this is blunt, but you should remember this, trusts don't die. Who benefits under the trust can change, perhaps based on someone else passing. But the trust can provide for me during my lifetime, and then figuratively, we turn the page, and after I'm gone, it benefits someone else. When you get to that point, that really can look a lot like your will would look like. But if you're using a trust, you avoid probate if the assets are already in the trust. So think about what I told you with a joint tenancy deed, that at the first death, the first spouse, the house will transfer, the full ownership stays with that surviving spouse. But then we have to figure out, what do we need to do to make sure we don't have probate if we don't want probate for that surviving spouse? Well, if instead those spouses created a trust, just one trust, and they titled the house in the name of the trust, and that's very easy to do. We just file a deed transferring the ownership to the trust. Again, the trust doesn't die. Who's benefiting under it changes. But spouse one passes, the house is still in the trust, no probate. Spouse two passes, house is still in the trust, we just need to find out what we do with the house now. So there again, it doesn't matter if your house costs, or the value of your house is $80,000 or is $8 million. You can have the same benefit of not having to involve the court when you pass. It also keeps it very private. And by using a trust, we can also ensure that whether you have a special needs family member or there's minor children, or even if your child isn't a minor anymore, if you've got a child that's in their early 20s, you might be saying, wait, I don't want that child to have all these assets right away. We can use a trust to be able to make sure they get the benefit, or essentially there's a gatekeeper as to how those assets go out to anyone, regardless of their age. And a trust also can come in very handy, very useful if you have a blended family situation, where oftentimes if the family is made up of mom and dad and kids of that marriage, mom and dad may have the same wishes, intent for what happens with the assets during their lifetime and then for their kids. Well, if you've blended a family so that mom and dad have children from other relationships and perhaps children together, the wishes, they might act like they want it all to go one way, but if one of them were to pass, then there might be a thought, well, I'm just now going to benefit the children from my marriage, or from my initial marriage or relationship. This topic could take well over an hour on its own, but just know that by using a trust, rather than each person just using their own individual will, that there is a way that, not to overuse the word trust, but that the mom and dad in this situation can really feel comfortable or be able to trust that what they collectively want done can be achieved. So that, again, it's not necessarily based on the value of the estate. Another mistake I see, I have labeled as mistake number 4, forgetting to update beneficiary designations. Going back to one of the initial statements I made, if you have a beneficiary designation, like life insurance, naming someone to receive those proceeds, that's non-probate. So even if you have a will that says, at my passing, I want everything to go to my spouse, or I want everything to go to my kids, I sometimes will hear people say, well, I've updated my will, so I'm really glad I did that. I now don't have to call the insurance company and the bank and change all my beneficiary designations because the will control it. No, remember, you're absolutely right. No, it won't. So that I often tell people when I start working with them that while I don't necessarily need to see this, on occasion I will, and I'll tell you why that in a moment. But at a minimum, when you're in the process of doing planning, take the time to create an inventory list of your assets. Even though I'm telling you this now, you're saying, yeah, right, I know what my assets are, I don't need to do this. You might be surprised. Write down the bank accounts where they are. If you have insurance, where that is. Who is the owner? Is it really you, or is it your spouse, or is it both of you? And then also, do you have beneficiary designations listed? Same goes for retirement accounts that you might have at work, or life insurance that you have through your employer. Double check. Not that there's a right or a wrong, but I would be very surprised if there's no one in this room that finds that something they have listed is not what they think they have. And sometimes what can happen too is if people have been divorced, they might think, oh, I changed everything. You probably don't want something going to an ex-spouse. So if that's a situation, you would want to get that changed. This might be interesting to you. In the event of a divorce, with a will, even if you don't change a will, the law says if you've listed an ex-spouse in your will, it will be viewed as though that ex-spouse predeceased you, so he or she will not benefit. That's on the will, only on the will. If you have a trust, not so. If you're listing an ex-spouse, that person will still benefit, and definitely on all these things with beneficiary designations, those companies or those forms, they don't care what the relationship is. If you've listed someone's name, that's who benefits. Also, if someone has passed away, unfortunately, I've seen this, oftentimes the families will work it out, but not always. If you have specifically listed children to receive a benefit, and then, surprise, you had another child that you weren't expecting, and then you don't go update those beneficiary designations. I've seen where certain children aren't in there. There are ways that you can list any and all children and make sure it goes to the children or down that family line. But if you're listing by names, that might not be accurate. So I would strongly suggest that if you do nothing else or get nothing else out of what I'm saying tonight, check your beneficiary designations. And make sure too that the names, another thing, if you have, typically this would happen with, say, a daughter, that if she's had a name change from a marriage, update that. It just makes it go a little easier. Yes?
I did have a question about there are accounts that we have beneficiaries listed. When you do a trust, does all of that go into the trust?
Good question. She said right now, if you have beneficiaries listed, if you do a trust, do you need to do that, or can all of those assets go into the trust and the trust controls? Yes and no, and it's your choice. Typically, yes. Definitely if, say, it's life insurance or so you had a bank account that you wanted to do that, I would strongly encourage that you either have it be that it funds the trust right away, that the trust is the owner. However, there's sometimes if it's an account that you have a lot of activity in and you just prefer to do so in your own name, that you would at least name the trust as the beneficiary. Because if you name the trust as a beneficiary, it will automatically go to the trust at your passing. It's not probate. And some of those things depend on a person's age, health, what's the purpose. The one type of asset that cannot be titled in the trust while you're living is any sort of qualified asset. think about accounts that you have to take a required minimum distribution on, so like an IRA. And if you think about it, it makes sense. That required minimum distribution is based on your age, a human age. So we can't have a trust be the owner of it because the trust doesn't have birthdays, okay? Having said that, you can list the trust as a beneficiary to that. And that would be more detailed conversation depending on your situation. Yes, yeah. Okay, then, yeah, go ahead. No, don't.
So if I have an IRA
Uh-huh.
that is, I'm over 70, so I'm getting a RMD. If it's in the trust and I pass away and that trust executor is not 70, what happens to that?
Okay. She's asking about if an IRA goes through a trust and the person benefiting under the trust that would benefit from that IRA has not reached the age of 70 or 70 and a half yet, what happens? Again, I'll give you kind of the 35,000-foot view here, and I'm happy to talk with you afterwards too. If you have a qualified asset, so an IRA, to the extent you can name a person, name a human as your beneficiary, that will provide the best tax, best situation to get the best income tax benefit. In all senses, whoever's going to benefit from that IRA will have to pay income tax when they take the distribution. What we're talking about is what period of time do you have to take those distributions? If you send it to the trust, so after you pass, you say, I want the trust to be my beneficiary, then your trust has a list of maybe one or more people that benefit, maybe from all the assets or specifically that IRA. This is an area of law that's changing regularly. And right now, I guess to give you the summary, it kind of depends on the type of person that would benefit. There's going to be somewhere between 5 and 10 years is the maximum time that those distributions can be paid out. So, and it's not, the trustee is the one that would make sure it gets distributed, but who's going to benefit is the beneficiary. So it might be the same person, but let's say, I don't know, you had a sister who's the trustee, but then you have kids or nieces and nephews that benefit, then in that case, your sister would distribute it, but we could be basing it on perhaps on the age of someone in there. Right now, what's happening though is it has to go out over like a 5-year period, regardless of the age. The exception is if you have a very young person, we're able to go over 10 years. It used to be we could spread it over the age of the life of the beneficiary, and we could even wait until they were 70. The government just wants their money faster now, so we have to pay it out. And one thing, this could sound almost sarcastic, but I do want you to think about this because I will have clients who bring that up and they are concerned that their kids or a niece or someone is going to have to pay tax on it faster, or they're not even 70 and they're going to have to pay tax. Unless you have a minor child, and there's some situations with married couples, but really, in a very general sense, you don't have any legal obligation to leave anyone, especially adult children or just some random family member, anything. So if you happen to leave them an asset that they have to pay income tax on, just like you did, don't feel too bad. You're leaving them more than they had before you left it to them. And if it's just, and again, it's not because you're saying you have to pay income tax in this very short period of time. That's the law. And so, yeah, I don't know if that will change. It's been pretty consistent that way. But yes, there's ways that we can try to minimize that pain. Yes?
If you have an asset and you transfer it to someone on death, don't they get the cost as the cost value?
The step up? Yep. Yes, but that doesn't apply to qualified assets, to IRAs. What she's talking about is the step up in basis. And if you are using a revocable trust, your beneficiaries will still get that. And to put it very simply, if you, and I won't talk about a primary residence because there's special rules for that, but let's say you have an investment house or you have a stock account that you bought the asset at, let's say it's a stock that you bought at $5 a share. And today it's worth $25 a share. Well, if you sell that, you will have income tax consequence, capital gains. The difference between the $25 it sells for and the $5 you bought it at, you will pay capital gains, or it's subject to capital gains. If you gave that stock to someone else, you gave it to a family member, okay, today, they would get your carryover basis. Again, it's worth $25 today, you bought it at $5. You gave it to your daughter. She will take it with that $5 basis. Just because she's taking it at that doesn't mean she's going to pay any tax. But if she sells it, she essentially steps into your shoes and would have the same tax consequence. The point you're making is absolutely correct. Under current law, and it's been this way for a long time, if you give appreciated assets to someone at your passing, so either through a beneficiary designation, through your revocable trust, or through your will, they will get a step up in basis. So, using the example I used, if you wait instead to give it to that daughter, when you pass, she'll get that date of death value. So if it's $25 when you pass, that's the value she takes it at. Again, if she keeps it, it doesn't matter. It doesn't matter if you gave it to her during life or you give it to her at death. But if she then wants to sell it, you've minimized the capital gains because she took it at that date of death value of $25. If you use the trust like we talked about, and you put the asset in that trust, it still will get that step up because that trust stays revocable. You can change it. It's still, you have control over it until your date of passing. It just becomes irrevocable when you pass, and so it gets that step up, okay? The one thing is, though, there are always exceptions, but generally if it's a qualified asset, you're not going to get the step up. And if you think about it, as much as you don't like this idea, it kind of makes sense because you funded that. The reason that you have that qualified asset like that IRA is you've put pre-tax dollars in it. So at some point, somebody's got to pay tax on it, and that's why you don't get the step up. Yes? Qualified asset is something that has, the easiest way to remember it, something that has a required minimum distribution versus non-qualified assets. So if you have a brokerage account with mutual funds, stocks, things that you just write a check for, or that you pay for with after-tax dollars, those are non-qualified assets. And you would get the step up in basis. Qualified assets are like a 401k plan, an IRA, something that you have used pre-tax dollars. So you haven't had to pay income tax on, like at work, if you have a 401k, you have a payroll deduction. So you're not paying tax on that money, and then it goes into your 401k. So when you take it out, you have to pay the tax on it. Correct.
And non-qualifying, you've already paid tax. And then, of course, when you die, everybody else gets to pay tax again, because, of course, it's double taxation.
Well, that's fine. Yes. Yeah.
So a trust overrides a probate all the time?
If you use a trust, anything that is already funded to the trust, or if you've listed the trust as a beneficiary, then at your death, and that's the way all of your assets have gone, then you are correct, there will be no probate. Okay? Yes?
Our second question was, he has an annuity and a distribution annually. What if we pass away before we finish receiving all those?
If you have thought some of what we've talked about tonight is confusing, annuities are way confusing. What I will tell you is that annuities come in a lot of different flavors, and there is not one answer. I would suggest you talk to the advisor that you use with that annuity, because there can be different things that happen depending on how that is set up. Okay? Okay. Oh, sure.
You were saying before that, if I have a 401K and part of it is Roth and part of it is not, then those different buckets are handled differently.
Yes. Okay. Another mistake people use is relying on verbal promises. So somebody will say, oh, I'll leave you this when I die. You are so right. Yeah, that, I don't spend a lot of time in court, but I would say that the majority, other than just a simple hearing or getting a guardianship, for the things that have been litigated, I would say a lot of them boil down to these kind of things, where someone said, I get this, or she said, that doesn't work out well. The only, really no one wins. Perhaps the lawyers that are billing for that do, but nobody wins. So don't, and also not just in estate planning, but anything that deals with land. And technically it's anything with land, so even like a lease, or if you're purchasing a house, or any real property, a situation that's going to exceed 1 year, if you don't have it in writing, it is not enforceable, period, okay? So, and then with estate planning, the issue there is the person who may have told you, oh, you get this, they probably aren't going to be able to talk much about it if you're dealing with this after they passed. So, yeah, that just does not work. So even make sure you put those provisions in a will or in a trust. And actually, even when you do wills and trusts, there's another document that's referred to as a memorandum for tangible personal property. And generally, wills or trusts will refer to this. I refer to it as the memo. I've heard some lawyers call it the laundry list. It's a list that allows you, because it's in your document, reference to this, that allows you to make your own list. It has to be in your own handwriting. You sign and date it. You keep it with your original document. It cannot, you cannot list land, no real property, not your house, and you can't list cash or securities, your retirement account. But all of those priceless family heirlooms, jewelry, artwork, all the things around your house, you can list who gets what. So it's almost like you're saying, well, I'm just going to tell you who gets this, and I don't want to put it in my will. You don't have to, but at least write it down. And as long as you follow the instructions that are given to you by the attorney you work with, it'll be enforceable. And that's a good way to do it. And I don't know if anybody still does this. Well, yes, I do, because I just heard someone say this the other day. Well, my family knows that all the yellow stickers on the bottom of the things in my house go to Susie, and all the items with the red stickers go to John. No. No, don't do that. Okay. Yeah. And, you know, that might go. Yeah, well. And you know what? And why that worked is that would not be legally enforceable, but you evidently had a grandmother that made everyone believe that morally it was enforceable. And so if people believe that, it works. Yeah. So that will. Another mistake is for people, oh, no, that's fine. Go right ahead.
You mentioned cash.
Yeah.
What about
Coin
coin collection?
collection. I often bring that up to people. I say you can't list cash, but yes, a coin collection because it's a collectible. But what I mean is you can't say like $500. Okay, no, very good question. You know, I'm not even going to say I know enough to be dangerous about that, but I would suggest you do not list that on your memo. And that,
I think that would be more like where you, like 401k or listed as crypto would be more of an investment.
yes,
Stock or something.
you are absolutely correct. Okay. Another mistake people make is not planning for incapacity. And I touched on this a little bit at the beginning for the need for power of attorney documents. Because without those documents in place, if you lack the mental capacity to create one of those documents and you can't access, say, a bank account that's in your own name, or your house needs to be sold, perhaps you lack mental capacity, you need to move into an appropriate care facility, and your house has to be sold to let you do that, well, especially if you're a single person, nobody has the authority to sell the house. And you'd say, well, just get a power of attorney. Well, you can't because you don't have the mental capacity to sign that document. And that's when we then get into having to have a court appointment. The other thing, as we're touching on power of attorney documents, those you have named an agent. You've given someone the authority to act on your behalf. You have not given them ownership. And that can be very important for people, maybe you have 2 or more children, and you're naming, you want one child to help you. Don't put, this kind of goes to the sticker comment, don't put one child on that bank account and say, especially, you know, if I'm not sure what I'm doing, I give you access to this bank account. When you list someone on a bank account, you list someone on your brokerage account, they are an owner. So when you pass, legally, they are the owner. If your will or your trust says, I want all 3 of my children to get everything equally, if one child is on that bank account, legally, he or she is the owner. Morally, to the sticker point, that child might realize, oh, mom wanted me to share this, I'll share it. Legally, they don't have to. So, but if you named that child instead as your agent on your power of attorney, he or she has the authority to act on your behalf, but can't have any selfish benefit on that account. And once you, the principal of that power of attorney, passes, that the authority that the agent has stops. Think of it. You're the principal. Once you die, there's no one for the agent to be agent for. So the authority of that power of attorney document, both for financial purposes and health purposes, stops at the passing of that agent, or excuse me, of that principal, which then means we look at what happens with the trust, or we go to the will, or then suddenly those beneficiary designations on the various accounts all come into play, okay? Yes, so.
Can the power of attorney for health purposes, for example, his father, and he has 2 sons, can both sons be listed as the power
Yeah.
of attorney for both?
Yes, you can list individual agents or you can list co-agents, so more than one. And I actually routinely suggest, especially when it gets to the level, maybe a spouse, for example, is the primary agent for health, but if a spouse isn't able to and then you have multiple children, if you would trust all those children to act in your best interest and to play well together when it comes to mom or dad's health, I think it makes a lot of practical sense to list them, because if you had a long-term illness and they were going to kind of tag team on taking care of you, or they live in different locations, if you list them all and give them all equal authority, then they all have that right. Whereas if you list them in order of priority, if a hospital or if the doctor's office is truly going to follow that, document what it says, and child 1 can't make it that day, so child 2, in order goes, that doctor's office could say, unless you can prove that your sibling, child 1, isn't serving as power of attorney anymore, I can't talk to you. And so it can become a little restrictive. Now, I don't, right, unless you name them as all as co-agents. I'm not as much of a fan of that with the financial, because that you can have some gaps, some overlap and some gaps. And honestly, where that if you have more of a power struggle with kids and somebody's like, I'm going to write checks or I'm going to take the money and not tell my sibling. If the kids get along okay, then it works. If you do that, though, I would suggest for financial that you think really hard about it, especially if you're going to list more than 2. Banks, insurance companies can deal with having 2 agents. So like mom can't act for herself and we've got a power of attorney that shows 2 kids are co-agents. If you have 2, they usually are fine. They'll just want the document to be very clear. Do they have to do everything together? Must they act jointly, or can they also act individually? But once you have 3 or more, most frontline people at the banks and at insurance companies don't know what to do with that, because they've been trained, you might have 1 person as agent, or sometimes people have 2. If you have 3, they just don't know what to do with it. And then you're being sent to the legal department, and it's, okay. So it becomes a little confusing. One more mistake that is often made is ignoring tax implications. And don't worry, we're not going to go into detail here. I'm just making that statement. I am a huge believer in the team approach when we're doing estate planning. And if we have situations that address tax issues, and I told you I have a very strong tax background, but I don't know what your individual situation looks like. I don't do your taxes. So I like to involve a CPA or your tax preparer, but ideally an accountant, a CPA that you're working with, to make sure that even though the document I might prepare is perfectly fine, legally enforceable, makes a lot of sense, but they're not one size fits all. And we want to make sure that we're not just accidentally or, whatever, that we're not looking at some tax issue that we should. We already talked about the step-up in basis issue. Right now, the federal estate tax threshold, so sometimes people say, oh, there's all these death taxes. Well, Colorado does not have any state-level tax that anyone has to pay because of death. I also practice in Nebraska. Nebraska has inheritance tax. So anyone that receives anything, regardless of where you live, if the person died or was a resident of Nebraska when they died, all their beneficiaries get assessed a certain tax, okay? in Colorado, the only type of death tax that you have to worry about is federal estate tax. And that, at the first of this year, that threshold went up and is now permanent. I say that somewhat loosely because it's permanent until it gets changed again, but they say it's permanent. And for an individual, it's $15 million. So it's a pretty high bar. And we're still able to look at a married couple as a unit. So if you're married, we're able to say we can get that up to 30 million before there's tax. Having said that, is there any way to plan around that to just not pay it? No, but there are certain techniques that we can use to try to minimize it. So, mistake number 9, not making your documented wishes accessible. You did everything you were supposed to, you prepared an estate plan. Do your kids, your spouse, your family, whoever's gonna help you, do they know where your documents are? Yes?
If my mom's on the house deed, and my dad's the only one left here,
His mother's passed away.
my mom has passed away, what's the scenario for that situation?
So your mom was the only one?
My mom has passed away
Uh-huh.
6 years ago. My dad's the only one left here, and she's on the deed. How does that affect the
So,
sale of the house?
so both your mom and dad's names are on the deed, or just your mom's?
No, if my mom is on the deed and my,
Both names were on the deed.
Okay,
She passed away.
yep,
He had a crash in his van. She's still on the deed. It took him 2 months to get the money because he had to take her name off the deed.
yeah.
He says that the deeds, all of his truck title and his thing, he says everything is done with that on-death transfer.
Yeah, then for each,
Take her name off the deed.
yeah, each of those offices, so if it's the clerk and recorder for the deed, or if it's DMV for the vehicle, there's different process for each office, but you essentially have to just show a death certificate. Because if it's joint ownership, then you just have to show the death certificate.
Went to the DMV, he gave him a death certificate, paid $7, they took her name off the van deed. But still, the check from the insurance company, they said, no, you have to open an estate bank account, or we won't give you your money.
Yeah, that's another issue. That's not because of the deed, that's because of who benefited. And if both of them did, then in order for mom to negotiate that check, she can't. And so an estate has to be opened, a probate, so that someone has the authority to negotiate it, and that would be the personal representative of her estate. So while to you, logically, and I get it, you think that's one issue, it's just because of the car, but it's not. It's because of how the proceeds are being issued. I can talk to you in a minute after that. Yeah, there's a lot of layers there. Yes?
I have a form that I got that I listed on my car. I just put who the title should go to. Is that valid?
Yes, I think what you're talking about is that you have prepared a transfer on death title. And it's very much like an insurance, like a life insurance policy where you write the designated beneficiary. Yes, you can do that. And it's also possible now to do that with with deeds for houses. I've done those. I don't think, not to overuse this phrase, it's not a one-size-fits-all, and sometimes things that just seem like they're really easy, there's some unintended consequences. I think the car makes a lot of sense. I get a little hesitant with the house.
Okay, I have a friend that worked at a title company, and she did that for me, but now my daughter has disowned me.
Yeah.
And I feel like I need to just give it all to the other daughter.
Yeah.
Do I have to go back to ground zero?
Yeah, with the title, the one benefit with the transfer on death, be it a deed or a title, it at least keeps the control in you while you're living. So yes, you need to do that.
But now I don't want the other daughter to get anything.
Yeah, yep, you're still in control.
I have to get a lawyer to get that changed.
Most generally, yes, unless you know how to do the deed yourself. The car you could do on your own. Yeah, the deed, yeah. N- Yeah. Yeah, it can get confusing, but yeah. The last thing that I will tell you in terms of mistakes, and then we are out of time, and I'll let you get on with your evening, is to not get professional help. And actually, you and I didn't talk before this, but your questions to me just now are a perfect example of this. That there are certain things you can do on your own, but I just get really hesitant if people just piecemeal things, because this is all, it's all your overall plan. And unless you get some professional advice, you potentially are going to have the family disputes. We go back to what I said, that you would potentially have very costly reaction rather than just get things done right ahead of time. So, yes.
Somebody told me that I have to give something to that other daughter, or she could test.
No, she's talking about if, whether you provide for children equally, do you have to do that, or they can contest? Anybody, I usually put it in these terms. It doesn't matter what you do in any sort of planning at all. Somebody, or not even planning, I mean, anybody could try to sue you. Anybody can bark. But the question is whether or not there is a bite. And you have no legal obligation to leave anything to any adult child, period. If someone feels that, oh, you should have given me something, they might try to file a lawsuit, but it's not going anywhere. I think if you're doing a will or a trust and you're dealing with that situation, there's specifically things to include or not include, but you generally just don't address it, or you make it as clear as possible. Like, I am intentionally not leaving something to this person. But I've had people say, well, let's just say we're leaving them $1. No, because that is where you see then people say, oh, they left off some zeros, and I've seen that, yeah. So, yes? Did I? Oh, okay. I think I included that kind of in another, and I didn't tell you that. No, you're right. There are generally with documents, there's no expiration date on signatures. You don't have to update. Depending how you word your documents, you might refer to children or descendants, so you don't necessarily need to change. However, if you have been divorced, if there has been births or deaths, your financial situation is different. You might want to at least revisit your plan. I tell clients it's a good idea to revisit your estate plan. Just even if I'm working with you, have a short conversation with me every 3 to 5 years. It might be that we don't change anything. There are certain things I like people to put fresh signatures on. But that's, if life happens, then at least talk with whomever it is you're working with on your plan to make sure that it's appropriate. So, well, thank you. I will wrap up now, so any of you that want to escape, you can, but I will stick around for a little bit. Or if you have questions, please feel free to give me a call or shoot me an email. Thank you for your time.